when a file comes to me, it's either a good file or a bad file. I can put some lipstick on the pig and I can try to build it up and maybe get it resolved. But if it lacks the underlying foundation, if it lacks the underlying documentation, it's hard to go back and recreate that. So, I think the biggest thing you can do as a public adjuster is have that documentation. If you have that documentation, usually that prevails, right? Usually that gives you a good underlying foundation. But if all you have is your estimate and some photos, that's not really, it's kind of a house of cards. It's very easy to knock that down. So it's the additional things. It's that documentation. It's the complaint process. It's the emails. It's everything else that happens outside the, here's our proof of loss and here's the denial letter. All those interactions that go on, a lot of those are actually verbal, right? During the re-inspections or over the phone call with the adjuster. So documenting all that in writing. How many people have been deposed before to building the foundation for the claim? Once? Okay.
On the one that you and I had a drink on.
Yes. So I think Cal and I are going to start looking to do some workshops on it and doing some, I do in the boot camp just kind of a little bit of a depot overview. But I think we're going to do kind of a 1 or 2 day class on how to do the depositions. And also if you're going to be working as an expert, how to kind of work as an expert and how to build your files doing that. So that's something we're going to be looking into doing. I think there's a need out there. I think there's people that want to do that. So that'll probably be one of our next, kind of pop-up sessions we do. Would be deposition prep, how to be effective in a deposition, and how to prepare for the litigation side of that.
I've noticed a lot of attorneys from Florida rushing to set up offices here in Texas.
Mm-hmm.
I mean, they and then the way I've heard it described is, man, it's like a gold rush. What's going on?
I'm kind of scratching my head on it. So, the laws have changed. And after 2017, we actually had some tort reform here in Texas geared at insurance claims. In particular, like windstorms, hailstorms, kind of mass event claims. So there's not been any trigger in the law that's, kind of, prompted that. I think it's more propelled by a lot of carriers in Florida. The system's kind of bankrupt. You have carriers that are going into bankruptcy, and you have some tort reform that's coming in that state, coming down the pike. So I think they're looking to kind of diversify more than anything else. I don't think there's anything in Texas that's necessarily drawing them, other than the fact that we do have some good laws here on the books. But we've had good laws on the books for a while, so that's not anything that's new.
Okay, so it sounds like, because I'm thinking it was something happening in here, but it's something that's happening in Florida.
I think it's happening in Florida, and it's driving them to start looking for more opportunities, would be my guess. But, I handle cases in Florida, but I'm not a Florida attorney, so, I've always practiced here in Texas, but that's my thought, is it's more some tort reform coming down in Florida that's driving some attorneys to start looking for Texas claims.
Completely different subject. They say when you see rats leaving a ship, it's
sinking?
Yeah.
Yeah.
Okay. Completely different subject.
So you always have those people that think the sky is falling, right? And some people are just scared of their own shadow. They're going to try to do tort reform. They did tort reform here in Texas in 2017. There's people that said, okay, well, first-party claims are dead. I'm getting out of them, because this tort reform is going to kill the industry. No. It changed some things. You have to have a little bit better documentation now. And it, on the legal side, it changed kind of some of the pre-suit notices and some of the provisions. But it has not negatively impacted the case. A good case is still a good case, right? So now, no matter how many different dots we have to dot our I's on and T's we have to cross, they may add more steps to the process, but the underlying claim is still there. And so I think in Florida, no matter what the law comes down, how it changes, you're going to be able to evolve and adapt around it. Now, in the short term, a year or two, it may take some time to navigate around that and know how to work it. Like in Texas, a lot of these cases ended up going to federal court after that law changed in 2017. So now we get like 95% of our cases in federal court. But I was just in federal court in Fort Worth a few days ago, and that federal judge chewed out State Farm and basically said, stop removing cases to Fort Worth. And so, sometimes there's unintended consequences of changes in the law, and I think some of that's starting to come home now in Texas, and I think that'll play out in Florida as well. Can I answer your question?
Yeah, I mean, now that you mention it, I get it.
Yeah. What else?
What about our involvement? Some of the things Renee was talking about this morning in there, just going, some of the stuff TDI is accepting as change and that kind of thing. Is there a place where we can get involved, leverage our influence if we have any at all, or what?
Absolutely. So
we can be doing there, to counter that.
First thing, coming and participating at conferences like this, National Claims Institute, the boot camp, other things where we're getting training, getting people together, that's great. But when Cal, Melanie, and I started PPA, we did it for a reason, because it's Policyholder Preservation Association, because the insurance companies are never going to stop trying to chip away at the rights, right? They're going to try to change the law, they're going to try to change policy language, so we have to preserve what's there. So I'm going to be talking later in the week about how you can get involved with PPA and have some legislative days in Austin, here in Texas, where we kind of push back on some of this. I think you're going to see some new changes coming down as far as appraisal is concerned in Texas. And we want to try to get ahead of some of that. So, we want to have a seat at the table when that discussion is going on. And so there's ways to get involved. And I think through PPA, we're going to kind of lead a lot of those initiatives.
So we'll be hearing more about that, how to directly do that. Or
Yeah, I think organizing and getting out and going and talking to state reps and state senators, next legislative cycle, things like that, we're going to help try to coordinate on this end. So.
Why does it seem that TDI so freely changes things, like for Badger?
Yeah.
Well, I mean, it seems like whatever he says, they jump on it.
Yeah.
Why?
Zero accountability.
Zero accountability. In Texas, it's a file and go state. Basically, you file your changes to the policy, right? And TDI doesn't necessarily have to approve each individual change. You're just going to have to file it and let them know what you're doing, give them a heads up of it. But they don't go in and actually say, we're accepting this proposed change or we're rejecting this change. At some states, you have to specifically get each change approved.
Right.
In Texas, you don't. It's basically, they've deregulated the market. And you used to have, the HOA, the HOB policy, HOC, and that was a standardized policy where it had certain coverages and certain exclusions, but it was basically uniform across the board. An HOA from Allstate was the same as an HOA from Farmers or State Farm or whatever.
How do we get that changed?
Yeah, it's a deregulated market now. And so now all these carriers, you have like hundreds of different policies written all over across the state. So I think one is to try to stop some bad law from coming in, but the other way to change it is to collectively work together to stop bad precedent from happening. Because once bad precedent gets out there, right, that negatively impacts all cases. And so, the attorneys working together, different law firms working together can help. But I think as far as public adjusters, all of y'all working together on how you're documenting the file. I was telling, I think Aaron earlier, when a file comes to me, it's either a good file or a bad file. I can put some lipstick on the pig and I can try to build it up and maybe get it resolved. But if it lacks the underlying foundation, if it lacks the underlying documentation, it's hard to go back and recreate that. So, I think the biggest thing you can do as a public adjuster is have that documentation. If you have that documentation, usually that prevails, right? Usually that gives you a good underlying foundation. But if all you have is your estimate and some photos, that's not really, it's kind of a house of cards. It's very easy to knock that down. So it's the additional things. It's that documentation. It's the complaint process. It's the emails. It's everything else that happens outside the, here's our proof of loss and here's the denial letter. All those interactions that go on, a lot of those are actually verbal, right? During the re-inspections or over the phone call with the adjuster. So documenting all that in writing is key to building the foundation for the claim.
Is the insurance elected or appointed?
He's appointed through the governor. Yeah, so it's a political appointee. Yeah. And TDI is, they're never going to come in and adjudicate the facts of all these individual claims and say you're right and Allstate's wrong or State Farm's wrong on this. But filing complaints is key, especially like prompt payment provision. Okay, that's strict liability. So if you file a complaint on that, TDI should act. And collectively, as public adjusters, start looking at what they're doing in your files and file complaints about commonality of issues you're seeing. Like after Hurricane Ike, I started filing a bunch of complaints about lifted shingles, where TWIA was just not paying for lifted shingles. Public adjusters, other attorneys started filing complaints on that. And eventually, I don't know if it was complaint number 101 or if it was complaint number 301, right? But eventually there was enough complaints there that TDI said, we're going to take a look at this. And they issued a bulletin about lifted shingles, and that is damage under the policy. So what TDI is charged with doing is basically like a game of whack-a-mole. They're supposed to go in and look at which insurance company is getting the most complaints proportionate to the number of claims they have out there. And whoever's the most egregious, those are the ones they're supposed to go in and investigate. So right now, I'm filing a lot of complaints against USAA because I think the last several years they've been acting the most egregious. It's been a quick slide from how they used to adjust claims. So filing complaints is kind of a long game, right? You create immediate documentation for your individual case, but all those complaints eventually add up, and there will be a straw that breaks the camel's back. And so file complaints about, if they're not paying for overhead and profit, if they're not paying for starter strip, if they're not paying for drip edge, if they're, any of these common issues, you can look at it and through your own files say, I got Allstate not paying on overhead and profit on 12 cases. So file a complaint and list all 12 of those individual claim numbers, because it shows what this is ongoing. This is something they're doing across the board. And that's something also that catches the attention of TDI, because they're looking for things that when they do want to come in and issue a bulletin on something, it's big picture issues that impact a lot of different things, not just one individual claim. So start looking for some of that. Engineers, they bring in engineers all the time now. When I got started, rarely did we have an engineer involved. Usually it was like a really large loss or something that legitimately had structural damage issues. Maybe a high rise or something, and we had, whether it was racked or torqued from the hurricane. Now engineers are involved on every case. Okay, and so you're kind of the front line of defense out there. You're having to fight back against the engineer. But in fighting back against the engineer, a lot of times they build their reports based on one underlying assumption, right? So if you disprove that one underlying assumption that the whole report's built off of, right, you don't have to go in and negate point by point everything in the report. You just have to go in and negate one or two items in the report, right? And a lot of times they use language such as, we assume, it's vague language, it's ambiguous language. So calling them out on that information, appears. They use that language all the time in reports. This appears to be mechanical damage. Well, what evidence do you have that it is mechanical damage? If it is mechanical damage, what caused it? When was it caused? Right? Kind of bringing those issues to a head so you don't let those, basically it's kind of like pointing out the fallacy of their argument. You don't let that be left unchecked. Does that make sense? Mm-hmm. All right. I don't know who had the hand first, so we'll go here.
In relation to the engineer, what are your thoughts? Because I've heard multiple opinions on, say, if a claimant, we look at it and we're like, okay, we think they're going to send out an engineer here, so
Yeah.
we send out our engineer first. And then when we send our documents to the carrier, we send the engineer report. I've heard that if that happens, then it will cause more damage to the client later on if it goes to legal. Is that true?
So a couple things with engineers. One, keep filing your complaints with TDI, but the engineering board is who you should be filing complaints with when it comes to engineers. Okay, and they're more prone to act than TDI is, unfortunately, because if you look at TDI, it's kind of the fox guarding the hen house in some respect, right? But if you look at the engineering board, right? Most licensed engineers are not earning their living adjusting claims in Texas. It's a few captive engineering firms that do that, but it's not the industry as a whole, right? And so there's been some good victories, where the engineer board has actually said, yes, this is malpractice, or this is, not in compliance with engineering standards in Texas, and it ordered some engineers to go back and take ethical training. So start filing complaints to the individual licensing board. Same thing for anybody that has a license, file a complaint to their licensing board, whether it's an engineer, architect, or whoever.
So, then,
I'm sorry, but let me get back. You were asking about sending out an engineer first. I don't think, there's a lot of cases I get, virtually everyone that has an engineer involved. I don't go out and think I have to immediately get an engineer to go refute another engineer, right? If it's a roof damage claim, then I'm just going to use a construction expert to refute that, because I don't think you really need an engineer to go in there and say this is damage or this is not damage. So I kind of avoid the arms race with them to some extent. If there's legitimately a need to get an engineer in, then I'll bring an engineer in. But I've never had a carrier say, you know what, Shaun, we got your engineer's report and we're changing our position. We like your engineer more than we like our engineer. They're always going to hide behind their engineer, right? So no matter if you go get an engineer report, it's not going to usually move the needle. Now, occasionally, rarely, it will, but usually they're still going to say, you know what, our guy says this, so we just disagree with your guy.
and if your engineer produces a bad report, it's discoverable.
Yeah.
Yeah, of course.
Right. So, yes.
So the state of Texas Engineering Practice Act rules concerning the practice of engineering and professional engineering licensure. It's a whole document that has what an engineer is supposed to represent, similar to the Department of Insurance that we hold carriers accountable when we file a complaint. Because I filed a complaint on an engineer, and I went in there and I read this whole thing and highlighted all the different things in there that he's basically not adhering to as an engineer. So
Yeah.
I filed the complaint, spotlighted those things, and they, with their initial review, moved on to the next level. Like they saw enough validity in what I turned in that they're taking it to the next level.
A lot of these engineers are not going out and using engineering principles. They're just opining about stuff without any actual documentation to back them up. Why is this mechanical damage? Because I'm looking at it and it appears to be mechanical damage to me. But they have no hard evidence to back up how they reached that determination, right? So when they're going out there and they're just opining on things without having scientific or credible evidence to back them up, then I would start calling them out on each and every one of those things, and kind of ask those questions, bring that issue to a head, and then ultimately file a complaint about it if you don't think they have a logical basis to make that assertion.
So if an engineer's saying he's basing his observations off a study that had over 200 roof examples within this study, but then when you go and pull up the study and it's dealing with a built-up roof system, and they only had 2 built-up roof systems in the study, and he's basing everything off the study, is he incorrect for doing that?
I think you'd certainly be misrepresenting the validity of the underlying study that he's relying upon, right? And so a lot of engineers rely upon reports and papers, that are published by Hague or Donen or, other white papers that are put out there. A lot of times when you go actually get those papers and go through, you'll find some information that's helpful to you, or at least negates some of their argument they're making. They're cherry picking the information out of the report that they want to use in the claim. So I've defeated a lot of engineers just by going and getting that underlying documentation and saying, okay, well, yes, I see where you're citing this on page 3, but what about page 2 and page 1 and where it talks about this on page 5? So a lot of times they're taking things out of context when they rely upon other documentation.
I had a claim where the engineer came out, they did a report, and then after reviewing the report, June 18th was a storm date for the hail. And on the report, they reported that it was on June 12th and that there was no hail on those dates. So we've contacted the engineer, we've told him, hey, you have the wrong date of loss. I don't know who gave it to you, if it's a mistake or the insurance, but it's wrong. Here's the correct last year's report, plus the community hired their own engineer that confirmed that they had hail on that day too.
Mhm.
And they said, well, I can't do anything until, you know, the Nationwide hires me to change my report.
To revise it, or, yeah.
Is that complaint? Could that be a complaint?
Yeah, absolutely. I'd file a complaint on that. And you know what Steve Patrick was talking about this morning about, you know, asking questions. That's one of the most important things you can do is ask questions and document the response you're getting back from them. You know, because a lot of times you're not going to win just by saying I'm right and you're wrong, right? But you can ask questions about how did you reach that determination, right? What were you looking at when you reached that determination? What about this? Have you reviewed this additional information? You know, if they're saying the lifted shingles were construction defect, okay, well, what about the mat transfer right here? Doesn't that indicate that it was properly sealed to begin with, or at least some point in time it was properly sealed? Okay, wouldn't that undermine your determination that this is construction defect? So a lot of times asking questions is some of the most important things you can do.
We did ask him if, you know, Nationwide actually provided him that date.
Yeah.
They could have, you know, gave him the June 12th date, which is incorrect, but he said that, you know, he couldn't give us that information.
Yeah, I've got a lot where they look at a window, let's say it's June 1st to, you know, July 30th. We reviewed it and done an inspection and there is no weather data that backs up this claim. Well, our claim is May 31st. And you started looking the day after the date of loss, right? And I've found that a lot in engineer reports where their window where they're going to look for weather data, you know, is just before or just after, but it's kind of buried within their report. And so if you go read the conclusion page, right, the assumptions that he's making is not based upon facts.
With very vague language.
Yes. Very vague, very ambiguous, which when you read it, it's kind of, sort of, maybe, could be, possibly. Okay, so what's this report really saying? I mean, it appears on its face like you're saying there's no way this could be, you know, hail damage or wind damage or whatever. But it's based upon so many assumptions, right, that they're way out on a tree limb by themselves because it's assumption after assumption after assumption. And if all three of these assumptions are correct, then I'll reach this determination.
Is a judge or a jury, when you're in court, does the fact that he's making up 100 different excuses to not tell the truth work in your favor?
It does, but we need that documentation. I can ask them that in a deposition, but it's more important if you ask them those questions and document it during the adjustment of the claim, right? Because now we at least have some evidence that there were either misrepresentations or they weren't properly adjusting the claim in good faith, right? So a lot of times I'll overcome a claim because why do they bring engineers in?
To build a bridge.
Plausible deniability, right? It's plausible deniability. We brought an independent engineer in. We use an independent adjusting firm to come out there and adjust the claim. So the desk adjuster is going to say, well, I relied upon the information from the IA firm. And the IA firm is going to say, we relied on the information from the engineer, right? So I'll take the depositions first of the desk adjuster and the IA. You relied completely upon that in making your claim determination to deny this claim, correct? Yes. So if there's something in that underlying report by the engineer that was not accurate, you'd have to go back and reevaluate your claim determination, correct? Yes. When I go take the engineer, all I have to do is now undermine one of the basis for how they reach their determination, right? Call into question the rationale and the methodology they used in reaching that determination.
If you have a flat roof with metal coping, really no damage to the PVC roof system, but you have damage to the coping that's built into the PVC roof. Engineer says there's no damage to the PVC, says there is damage to the coping all the way around the building, but it's really not functional damage. It's playing no part of the roof system. Is he at fault or is the desk adjuster at fault for not reading the policy?
The desk adjuster.
Ultimately, the desk adjuster is responsible, right? So they're responsible for the adjustment of the claim and making that.
The engineer kind of built her up
Right.
to say, well, we don't have to replace that.
Right. So they're relying upon ladder now, ladder assist, the IA firm that goes out there, the engineer that goes out there. But ultimately, that's their determination, right, to accept or reject the claim. And if they're not doing their own due diligence, one thing I love to ask, like a desk adjuster, is you relied upon this engineer, correct? Do you know that engineer's qualifications and experience? No? What do you mean? You're relying upon them. Do you know their qualifications and experience? Yes or no?
He's an engineer.
He's an engineer, yeah. You know if he's ever installed a roof before? Because he's opining about a lot of things beyond what's in his field of knowledge as an engineer, right? He's talking about construction methodology and repairs and all of that, whether it's repairable or not. So if they don't know the qualifications and experience of the person they're relying upon, is it reasonable for them to rely upon that person?
But he's an engineer.
Yeah, exactly.
You'll get
Yes.
that email- You'll get that email response 2 days later.
To know what litigation,
Another question or two, and then let's take it upstairs and we can have a drink while we continue the conversation.
what you're doing to try to change, basically the appraisal process. It seems like it's very pro-carrier.
Yeah.
And there's no timelines to hold them to. It makes it very difficult to handle a claim if it goes appraisal is involved.
Right, that's, chief complaints about appraisal, it's the Wild West. There are no real rules of the road. There are no timelines. There's no rules of evidence, so anything goes. A lot of times you show up to like an appraisal hearing and they drop an engineer report on you and you didn't know they had an engineer report. You don't have time to like vet it to see if it's really reliable or not, right? So I think appraisal was a cool thing about 25 years ago before the carriers kind of weaponized it. And the carriers have now weaponized the appraisal process and they use it as like a sword and a shield, right? They want to hide behind it if the outcome is good. But then if it's the outcome they don't like, they want to say, well, wait. That doesn't determine coverage issues. So we still want to dispute on coverage. So a lot of carriers are now making it like, a two-step dance where you go through appraisal process, they knock down the damages. Now you still have to go sue us to try to collect on that. So it's kind of like they get 2 bites of the apple by going through that process. Maybe they win the appraisal. If so, it's over. If they lose the appraisal, they still got round 2, which is you got to go file a suit against us to try to prove it up. So I think you need some common sense rules of the road to try to bring it back to neutral. I think you need to have a license. Like if you have appraisers, they need to have some sort of oversight board, right? I'm not a big fan of big government, so I don't want to go create a bunch of new licenses and a bunch of regulatory agencies. But I think they need to be like licensed insurance adjusters or have a PA license, right? At least if there's something you're doing wrong, and I think there needs to be some ethical guidelines on how they adjust claims. I also think they need to have like E&O insurance, right? Because I'm starting to sue appraisers now. I have a claim that Rolf is handling with my office where the umpire sent out an email to the 2 appraisers and said, here's my award. By the way, it's changing 20% within an hour if one of y'all don't sign it. He didn't say if it's going 20% up or it's going 20% down.
Yeah, that's ethical.
But how is that a fair and honest assessment of the claim if you're willing to change it by 20% one way or the other, north or south? And so we're going to file suit against that umpire for that award. But there's going to be some legislative changes in Austin on appraisal this legislative session. Badger's pushing for legislative changes, so it's going to be on the agenda. There will be changes. Renee went over some of those this morning. They're not very favorable. We want to have a seat at the table, and that's why through PPA, we want to kind of get together, and I want to have a day or 2 days in Austin where all public adjusters come out, policyholder attorneys, and we visit with as many state reps as we can. We go to as many hearings at the insurance committee as we can to try to, at least bring it back to neutral with some of these changes.
Sign me up.
Yeah. All right, let's everybody go get a drink.